administration with the will annexed of the estate of the deceased. That primarily is to renounce the priority as the residuary estate beneficiary as trustee. Now, by the wording itself, you don't necessarily see the distinction. But then when we look at the checklist towards the latter part of this lecture, you should be able to see that we will need to clarify very clearly how the persons having a high priority has renounced. So if we are acting for the daughter, one of the ultimate beneficiary, then we'll have to indicate, well, number 1 has been clear, number 2 has been clear, number 3, no, non-existing, number 4, non-existing, number 5, well, the daughter is number 5, the ultimate residual beneficiary. We should take a look at that in a while, but for the moment, the emphasis is this. Voluntary renunciation must renounce all the capacities. You cannot renounce A and leave behind B. That is not sufficient. Then we have the constructive renunciation. Now the wording here is correct, constructive renunciation. This is involuntary variation. If you recall, there are 2 related parts in the probate registry which is related to this issue. Number 1, you can make a search on citation. Number 2, you can issue citation. So these 2 are related to this involuntary variation. These apply both to testate as well as intestate, because the emphasis is to make you to have become renounced your priority, causing you to lose your priority, so that the one that follows immediately after you will be elevated to become the highest in the circumstances, and therefore has the right priority to apply for a grant. So in other words, this involuntary variation is a kind of clearance. How to clear off people with higher priority? One way is this involuntary renunciation or variation by way of constructive renunciation. To be specific, now there are altogether 3 types of citation under the rules. So far as constructive renunciation is concerned, this is one of the 3 types only. It's the first one. This is what we call a citation to accept or refuse a grant. A citation to accept or refuse a grant. From the wording, although it may be similar in the 3 types of citation, this first type, your emphasis may be made on the word grant, G-R-A-N-T. The word grant itself means it's something that would apply both to the testate as well as the intestate situation, because grant is a general name. So constructive renunciation only apply to Rule 46 of Rule 1, which is in red. There are two other types of citation. The second type is called citation to executor having intermeddle with the estate. This serves a different purpose. This is a tool used to compel a named executor under the will who has done something in relation to administration of estate, but without actually clothed with the proper title as an executor under a grant of probate. So what this named executor has done is something arguably wrongful. And we call this kind of act intermeddle. This term intermeddle will be seen very often in different types of actions against various kind of persons who have dealt with the estate without authority. Someone has died, no grant has yet been made, and yet in the meantime, somebody has taken full advantage of this vacuum in capacity, has dealt with the estate, and therefore has taken a gain, a personal gain, to the prejudice of the estate, leaving loss to the beneficiaries. So the second type of citation refer to what we have just talked about, but only limited to those persons who are named as executor in the will, but yet who has somehow refused to apply for a grant. This is something trying to match the gap, because an executor being issued with a grant of probate has a duty for proper administration of estate. So if he has failed the duty, we call breach of duty, then one can apply to the court under Order 85 in order to ask the court to grant an order so that he will make good the loss to the estate. So, but if someone refuses to apply for a grant, presumably you cannot bring him under that umbrella. You may take action against him as some kind of a stranger, but that it may arguably comes in as a what we call catch-22 position, because if someone were to sue a stranger for the wrongs that they have done to their estate, this is possible. But in order that this is to be done, it has to be done by someone who has the capacity as executor. But now this is the executor who has done the wrong on the one hand and refuses to get the official title on the other. So it is this kind of situation. We want to compel him to take the grant, and if he refuses to take the grant, then somebody having a lesser priority can then apply for a grant, and then in turn sue the intermediate executor for the wrongs that he has done or he has done to the estate. Then we have the third type, which is citation to or to propound will. Now, probate action, this is Order 76, is a fight in terms of who should be given the priority to apply for the grant. So we are talking about Rule 19, Rule 21. We are talking about parties variation, express renunciation. But then this third type of citation, in fact, refer to a slightly different scenario. That is, if it is alleged or it is a fear that a deceased person may have made some wills, but we don't know whether if actually that he has made many wills, or whether the wills alleged to have been made is or is it not a will. Because a person who is old and dying may be signing various documents which may or may not be a will. So you may argue, then what then is the criteria? What then is a will? You will need to have a very clear mind to know what a will is. And basically, a will is something to give away your property, which will take place when you die. So that is a will. If something which amounts only to a gift, inter vivos, or something which is a gift conditional upon the death, they may not be the will. So of the three examples that we have just cited, number one, if this is a document which shall take effect inter vivos, this is an inter vivos gift. If this is an inter vivos gift, if this is a gift of immovable property, then it has to be done by deed. All right. If this is not an act of inter vivos gift, it may be a will, the third type. Well, if this is a will, then it may be or it may not be a valid will. If this is a valid will, it may be a Section 5, Subsection 1 formal will, or it may be a Section 5, Subsection 2 informal will, without all the capacity, formality being complied with. So you need to ask the court to examine whether this is an invalid will, meaning whether this is what we call a purported document comprising testamentary disposition. Or alternatively, again, this is the same person who is old and is about to die. He is not making an inter vivos gift. He is not making a will, but he may make some kind of a gift which is conditional on his death. This is the second type. This is not a will, because this is an inter vivos gift, yet with a condition. The condition is, I am dying. If I actually die, then this gift will become unconditional. This is what we call donatio mortis causa, in short DMA. There are a few decisions in the past judgments. So to owe an aged person about to die, then the next door neighbor used to take care of him. The old guy feel obliged, impressed by the services of the neighbor, so he is about to die. He gives to the neighbor a set of keys to say, look, this is my keys to the safe deposit box, or this is the keys to my safe at home. I'm about to die. If I shall die, all the contents are yours. So this is called donatio mortis causa. It is not a will because it is an inter vivos gift. A will is not an inter vivos gift. A will is a valid document which will only take place when you die. But donatio mortis causa is something which takes place inter vivos, before the donor died, but only conditional if he actually died. Now, the line is kind of fine and may not be easy to actually draw. But we always look at these three different types in order to measure against it on the requirement or formality requirement. And we also look at it from the point of view of substantial validity in terms of the intention. The first intention is an intent to make inter vivos gift. The second intent is an intent to make an inter vivos gift conditional on death. And the third intent, which is the testamentary intention, is making a gift which shall only take place upon the death. So the third type of citation is ask all the people concerned, why don't you bring all the documents if you were alleged that these are wills, take it to the court and give evidence to show as to whether or not this is a valid will, so that the court will, and in one go, determine the validity of more than one wills in order to find out which are the valid wills, and then also to find out which was the last will. So these are how the disputes are to be resolved. And the court time and again emphasize this. In respect of the same disease, if there are disputes in will, it's much better to conserve the time and the cost of the parties and the court to determine all the disputes at one go. So the third citation is meant to be this. For us, if we are to answer the question of priority of grant, it is only the first of the three citations which is relevant, namely citation to accept or refuse grant. So this is priority B, involuntary constructive citation. So priority C, this is variation by the court. the court has the highest say, the last word, has the last word on grant priority, the court will determine both intestate or intestate is for the court to, please delete the word T-E-S-T-E. There's a typo there. It should be the test, T-E-S-T. Delete the letter E at the end. The test is necessary or convenient. Is necessary or convenient. This is what we call a Section 36 grant application. Is Section 36 of Tab 10 PAO. So the court will consider the application, consider the evidence, and then make up its mind, which is a discretion, and then to decide whether the court should bypass the normal variation at priority A, the general rule, 19 or 21, or the priority B, parties variation, in order to come to the final words to say, under Section 36, I order that blah, 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 will be given leave to apply for a grant. I have decided, or this court has decided, to bypass the normal priority. Normally, there are a lot of fights between families with various siblings, various children, and they are having fights against each other. They have lots of money, so they don't mind commencing various court proceedings. So the court will then look at all these quarrels in order to decide, number one, who amongst the next of kin or who amongst the beneficiaries should be given the permission to apply for a grant. Alternatively, the court may then consider none of the parties are suitable because of various reasons, including conflict of interest or hostility. So the court will then make up its mind in order to say, enough is enough. I have decided to appoint an IPA as the administrator instead, meaning an independent, professional administrator. This will usually be CPAs, partners in audit firms, or where there are likelihood of various litigations, solicitors. Personally, I have come across actually having been granted order by the court to appoint me as an IPA, and I look at them, basically the court is satisfied that it's not just a matter of dollars and cents, which is best for auditors, but because of the fact that there are various litigations here and there. So the court presumed that it would be cheaper to appoint a solicitor to be an IPA, so that all the disputes can be resolved as cheap as possible. So these are the usual consideration by the court when it comes to priority C under section 36 of Cap 10. So what we have so far will be the rough contents for you to answer any questions on discussion on priority of grant in terms of people dying domiciled in Hong Kong. As opposed to people who died domiciled in Hong Kong, now we discuss another broad area, which is priority of grant for people who died domiciled outside Hong Kong. Sometimes it's not easy to determine a domicile because, as I said, you need to decide on two factors. One is the act of residence. You actually live in a particular place. Second is the intention. What was the intention of a deceased person that he has chosen to live in a place up to he died? The court will need to be satisfied that, all right, he actually resides in a place and then he intends to live there either permanently or indefinitely. Sometimes the fight is on the determination of domicile. This is because different countries may have different law on succession. So all these fights are of estate with sufficient size, and then they have their own legal advice in order to come up with the best solution. So they want to decide at their own battleground, better die domicile in Hong Kong, or domicile in the mainland, or domicile in, let's say, Australia, in the state in Australia. All these are due to various reasons to take full advantage of the law where the domicile or the alleged domicile, place of domicile, shall provide. When we talk about domicile or foreign domicile, usually will be a situation where he may die in Hong Kong but domicile outside Hong Kong. But of course, it's more usual that a person died in and domicile in Hong Kong, or sorry, outside Hong Kong. That is foreign domicile. But then there will be no dispute unless there are assets in Hong Kong. In order to understand the discussion or the complexity of the foreign domicile, these are the various scenarios that we must understand as a broad background. First, in a foreign place, remember, it's not a foreign country, it's a foreign place. In a foreign place where a grant is issued by the foreign court, well, in this place, a grant is required in order to deal with estate. and a grant is in fact or has in fact been issued, which that foreign place is within the definition of a designated place within the meaning of Chapter 10. The second type is the same as the first type, and the only difference is it is issued by the court in a foreign place which is not within the definition of designated place. The third type is where in the foreign place there is a need for a grant to be issued in order to administer the estate in the foreign place. There is a need for a grant. But for some reason, no grant has been issued. There may be more than one reason leading to this. The most popular reason is the deceased died leaving no property in the foreign place that required to be administered. So either the deceased has got no assets overseas, or the deceased has left assets overseas that do not require a grant to be issued. For example, all the foreign assets are by way of joint tenants, so that on the death of the deceased, the right of survivorship shall apply. All the assets which the deceased had a share somehow do not pass on to the hands of the foreign personal representative, but rather operate by way of the right of survivorship to the surviving joint tenant overseas. So these are two examples for category C there, Charlie. Foreign grant required but not issued. There may still be other reasons. Is somehow someone tactically or intentionally do not apply for a foreign grant for reasons of trying to apply for a grant in Hong Kong instead. Category D is where foreign grant is not required by law for the purpose of administration of estate. If we are able to understand these four scenarios, the discussion on foreign domicile will be very simple and straightforward. Before we move on, we'll just give you some example to note. Scenario A, Singapore. Singapore is a designated place. Scenario B, a state in the United States of America. Scenario C, again, the same USA state. Scenario D, mainland China. So I hope you can understand these four scenarios and be able to understand this concept in a much easier way. Now, before we leave this slide, you can see on the right-hand side on top, I have listed out two sources of authority relating either to Section 49 of Cap 10 PAO or Rule 29 of Cap 10A, the non-contentious probate rules. So Section 49, Cap 10, or Rule 29, Cap 10A. First, this is the foreign grant, designated place. Under Section 49 and the schedule in Cap 10. This foreign grant issued by the designated place is something similar to what we understand as the resealing of colonial grant before 1997. Before 1997, we have the resealing of Commonwealth grant. So any members basically of former British colony or colonies, they now become a member of the Commonwealth. So one of the treaty was any grant issued by any member of the Commonwealth, then it will have the benefit of resealing, resealing, in Hong Kong. After 1997, something similar has been done as an attempt to continue the resealing. You can imagine by 1997, well, everything changed hands. But I think by consensus of PRC and England, they want to establish some kind of a tie so that Hong Kong can remain to have some past influence and past connections. Like we have the non-permanent judge in the Court of Final Appeal. That was something created specifically with the consent of PRC, so that we have a very funny system of what we call the CFA. when PRC has agreed, instead of in London by the Privy Council previously, or by the House of Lords, or on the other hand, by the court in Beijing, we in Hong Kong are permitted to set up the CFA and then appointed members either as permanent judge or non-permanent judge. As you can see, during the political issue or uneasiness in these past 2 years, there were discussion saying that the British government are refusing to allow British judge to come into Hong Kong to act as non-permanent judge sitting in the Court of Final Appeal as an attempt to cut off the Commonwealth tradition of Hong Kong. You can see there are various kind of discussion around this and saying that, well, Hong Kong can live without the non-permanent judge. The argument was that we believe in common law, but CFA is a creature so unique to Hong Kong, which was never seen in the world. So if we can have non-permanent judge, then we can also do without non-permanent judge. We are not at the mercy of foreign influences. As long as we are practicing common law, we can have judge appointed who speak only Chinese. We can have Chinese common law. Something similar yet different from Singapore. Applying to this, something very similar to this resealing in 1997. I think immediately after July 1997, the British government was the first government that entered into this treaty with Hong Kong. So they are the first designated place. So any grant issue in England and Wales, in Northern Ireland, or something similar to grant in the Scotland, these are within the meaning of designated place. The selling point was this. Any grant, any foreign grant issued by the designated place will be recognized by Hong Kong without the need of fresh application for grant in Hong Kong in order to administer Hong Kong assets. Very briefly, all you need to do is to provide the foreign grant or a court-certified foreign grant, take it to the probate registry, apply to affix the chop of the probate registry. That will have the effect as a grant issued out of Hong Kong, meaning issued in Hong Kong, in order to administer the estate in Hong Kong. The only other thing that needs to be done is on the requirement to state or to disclose assets. So this N4.1, N2.1 is the same. You make voluntary disclosure on assets, and then you take the foreign grant. That's it. I was told by a fellow practicing lawyer in Hong Kong. She told me that her experience is this selling of foreign grant is much easier, so much so that you don't even need to provide an authenticated death certificate in order to show that the person has died. Previously, I have done this selling of foreign grant before. I thought that I need to provide an authenticated death certificate. But then she told me, no need. You don't need the authenticated death cert for the purpose of selling of the foreign grant from the designated place. So if this is the case, that shows this is the easiest way to apply under this head, not for a grant, but for affixing the charge of the probate registry on the foreign grant issued out of a designated place. I then have another opposite example. I applied for selling of a foreign grant issued by a designated place, which is issued by Sri Lanka. Surprisingly, Sri Lanka is a member of the designated place. But my application is still pending now, not yet carried through. Because of what reason? The reason is this. The probate registry said, according to the authorities of Tristan and Coote, selling of foreign grant is permissible only if the foreign grant is issued in English. It's issued in English. Whether this should be the case, I don't know. There must be some controversial issues to be considered on this line. The reason is, what is the rationale behind it? What is the rationale that says it must be a grant issued in English? If things were to change, for instance, if we have a grant in non-English language, are we still bound by TNC, the English authority? Unfortunately, there has as yet no such case decided out of the High Court. So what they have done is, since there is no contrary statutory provisions in Hong Kong, therefore we shall accept the English authority as precedent binding on the local probate registry. So that perhaps is the rationale. So these are the designated place. Now, something beware, because this selling of foreign grants sometimes is also called reselling of foreign grants. So they mean the same thing. technically, the words in the statute now is selling of foreign grant, but historically, or used outside Hong Kong even these days, is reselling of foreign grant when they carry on the meaning and the terms under the reselling of the Commonwealth grant. So these are the presently the various places: United Kingdom, Singapore, Sri Lanka, New Zealand, and several states in Australia: Victoria, Tasmania, Northern Territory, South Australia. So any grant issued in any of these various places, you can apply for sealing of the foreign grant in Hong Kong. The example that I used to quote is, there is a marked difference between someone who died in Melbourne and someone who died in Sydney. These are the two places where most of the overseas Chinese are situated now in Australia. Melbourne being number 1, Sydney being number 2. Melbourne is within the state of Victoria, so you can have selling of this foreign grant. Whereas Sydney is in New South Wales, which is outside this designated place. So it is not possible for selling of this foreign grant issued out of New South Wales for people who died in Sydney. But these are things likely to be transient if the Australian government have decided to come to closer terms with PRC. No one knows if further concession or treaty can be signed by both places or both countries, whereby Hong Kong may benefit as a result. In order to expand the designated country or place, or by the same token, if we have further political confrontation, then these lists are always capable of variation. So it's a kind of transient. Every time you want to look at it, look at the time when the deceased died and see whether there is change in this designated country or place by looking at the schedule in Cap 10. So the next scenario is grant issue outside Hong Kong, which is not within the meaning of designated place. So this scenario B will require a Hong Kong grant to deal with Hong Kong assets of a deceased who died domiciled outside Hong Kong. So the major difference between this slide and the last slide is listed or not listed in Schedule 2, PAO. If it is listed there, then you take advantage of the designated place, which is easier. If it is not listed there, then this is a foreign grant. By the foreign grant, you apply for a Hong Kong grant. The next scenario, a foreign grant is required, but a foreign grant is not issued. So you can see the possible reasons. No foreign asset. The guy is rich in Hong Kong, but is broke in overseas. Or the foreign assets does not require foreign grant. Low value, joint ownership, as we have just discussed. So foreign grant is normally required to administer foreign assets, but as a matter of fact, no foreign grant has been issued in this particular case. So this is scenario C. Scenario D, where countries do not have such concept of a grant. People, you die, you die. Once you die, then the beneficiaries will be entitled to succeed on the property, on the assets. You don't need a grant. There's no such thing as a grant. So you may say, what then is a grant? What is a grant? A grant, according to the booklet of the probate registry, a grant is a court order. It is a court order issued so that a estate in Hong Kong can be administered. Look at something close to us. Again, across the border, they have no such thing as a court order like a grant that we are discussing in this module. So the estate can be administered without a grant. But more commonly these days, they have created something similar to a grant, and yet it's not a grant. When it comes to administration of the immovable property, which is done by way of a notarial certificate. A notarial certificate issued by the notarial office, then with the notarial certificate giving a declaration as to right of inheritance. So you have this notarial certificate of inheritance issued out of the notarial office, and you take that notarial certificate and take it to something similar to Hong Kong, the land registry, and you register the notarial certificate on right of inheritance. Then whatever is set in the notarial certificate as to who is entitled to inherit what, then these people mentioned in the notarial certificate will then become the owner of the immovable property. Strictly speaking, this is not a court order at all. For the purpose of Hong Kong assets, in order to administer the Hong Kong estate, then this scenario D will require an application of a grant in Hong Kong. Now we look at this whole thing for grant application from a different scenario. Apart from selling of the foreign grant, all these are under Rule 29. Now if you have the handphone or your notebook, let's go online. We'll look at the wordings so that we'll be able to understand them clearly. turn on your cell phone and go to Rule 29. Chapter 10A, Rule 29. Now, you can read the English or the Chinese version. And compare with the PowerPoint here. The first one, we have Rule 29A. You see, you need an order to be made in favor of person entrusted by the foreign court of domicile in order to administer the estate there. So in other words, Rule 29 small a, if in the foreign court, if this is not a designated place, so any other place, any other foreign court, not a designated place, then this is small a, Rule 29 small a. So, person who is named in the foreign grant, foreign meaning the domicilian grant, person named in that name are person entrusted in this PowerPoint, meaning person entrusted by the foreign court or by the court of the foreign domicile as stated in the foreign grant. This we call the person entrusted in short. So these are the persons or the person, meaning the foreign PR. Remember, this is a foreign court, the foreign domicile. So named a person representative. In that case, that PR in the foreign grant is entitled to apply for a Hong Kong grant to administer the Hong Kong assets by virtue of the foreign grant. They still need to apply for a grant, but the person entitled to apply for a grant is limited to the person stated, listed in the foreign grant. So they are persons entrusted by the foreign court as stated in the foreign grant in order to apply for a Hong Kong grant. Now, in practice, we have to be careful. Careful in a sense on two aspects. Number one is the person named or the PR named in a foreign grant, because the Hong Kong grant will be issued to the foreign personal representative only. Number two is you have to be sure that all the assets in Hong Kong are in the same name as appeared in the foreign grant. So this is a limitation. This is a limitation. Because if in the foreign grant, so a personal representative has been issued with a grant of a deceased named ABC. So the deceased is named ABC. If the Hong Kong assets are held by the person or in the name of ABC, then no problem. If there are some assets issued in the name of ABC and some issued in the name of CDE, for example, then there is a problem. There is a problem because you are making a grant by virtue of a foreign grant of a deceased in favor of someone handpicked by the foreign court. So you have to comply with these two hurdles. If you have no problems on this, then Rule 20A will be the first priority. You will have to explain why is that, well, you have admitted there is a foreign grant issue, and yet the person now apply for the Hong Kong grant under 29A is not the same person. Or you have to explain, oh, there are other assets in other names. But this is less of a problem. It's not applicable, it is not applicable. But if the applicant is a different person, you have to explain. And even if you can explain, you cannot explain away. Because the law says very clearly, only the PR in the foreign grant can apply for the Hong Kong grant, not somebody else. If this is somebody else, apply under different head, as we shall explain. Then, look at B, Rule 29 small b, person and title. Now here, it is according to the court in the foreign domicile, person entitled to administer the estate, meaning the estate in the foreign domicile. This 29b, the wordings are misleading. The wordings are misleading. The wordings are misleading because it refers to persons entitled to administer the estate without a grant. But these two words, without a grant, does not appear in small p, when in fact that must have to be the case. So in other words, what Rule 29b means is, well, in the place of foreign domicile, there is no such thing as a grant to be issued in order to administer the estate of a deceased. No grant is needed to be applied for, and no grant will be issued for that matter. Then, person who are entitled to administer must be person entitled to inherit the estate. So in other words, the plain reading of 29b is person entitled to inherit the estate without a grant. That is what it means. Then we have number 3, Rule 29c. This, look at the wordings, is 29 small c there. This is a discretionary grant to be issued by the registrar. Now, in the beginning of this lecture, we have mentioned about priority C of Hong Kong domicile under Section 36 of Cap 10 by the court, which may or may not be the registrar. It may be a probate judge, depending on whether this is contentious or non-contentious. But priority C is the highest discretion, has the last say, has the final words. The court decides for Hong Kong domicile, is Section 36. In the case where this is not a Hong Kong domicile, then this is a foreign domicile. In foreign domicile, the court now, this is called the registrar. The registrar will have a similar discretion. The registrar can then decide if one is relying on Rule 29c in order to decide who should be given leave to apply for a grant in Hong Kong in respect of a deceased with a foreign domicile and with Hong Kong assets. Usually 29c will apply to the situation, used to be, would apply to the situation where a foreign grant is required to administer the foreign estate, and yet, in fact, no foreign grant has been issued for the reasons that we have seen. Either estate too small or estate passed on by way of survivorship. So a grant is normally needed in a foreign domicile, but yet no foreign grant has been issued. If that is the case, this is a normal scenario where we apply under Rule 29c for registrar discretion. So I repeat, Hong Kong domicile court discretion is Section 36, Cap 10, whereas foreign domicile court discretion is Rule 29c here. Then forget about D. Small d simply provide for the situation of or on the minimum requirement of 2 administrators on estate involving life interest or minority interest. So strictly speaking, it is not what we need to be concerned with in terms of grant priority. Perhaps we should take a break now before we go to the provisos. Okay? Let's take a break now.